And just before we go, let's bring you highlights from the first ADR Roundtable for Lawyers organized by the Lagos Multi-Door Courthouse in conjunction with the state's Ministry of Justice. The Lagos State Judiciary, led by the Chief Judge, Justice Opeyemi Oke, has a mission to, among other things, provide a fair and responsive system of justice committed to excellence. And as part of achieving that mission, the first court-connected Alternative Dispute Resolution ADR Center, in collaboration with relevant stakeholders, organized the first ADR Roundtable with the theme Strategic Lawyering, Deal-Making and Rewards. The roundtable, which brought together lawyers, judges and other relevant parties, aims to provide a forum where the respective concerns of all stakeholders in the practice and business of ADR can be fully articulated and discussed without bias. The Chief Judge of Lagos, Justice Opeyemi Oke, was involved in the revolutionary reform which initiated the establishment of the Lagos Multi-Door Courthouse in 2002. She held the position of the first chairman of the LMDC Governing Council, and she is happy with this initiative.
This is the first major joint thrust of all the ADR institutions in Lagos State to penetrate civil society and commerce and propagate the ADR message. This initiative will undoubtedly create awareness among the users of these processes, and I predict that when consumers of justice develop a consensual dispute resolution consciousness and a healthy appetite for ADR, a ripple effect will be created which will impact the way lawyering business is carried out. The implication to the legal practitioner could be either pleasant or dire. This forum has therefore been conceived for lawyers to promote enlightened self-interest.
The roundtable examined, among other things, the role of the 21st century lawyer and the business of ADR.
The problem is that a lot of lawyers are still fixated. They believe that once you have a client, when you have a case in a client, the first thing you want to do is file your writ of summons and file your papers and go to court and have that lengthy process in court. And business people don't have time for that. So lawyers need to then look at things from the point of view of value. What value are they delivering to their client? And when they do that, you realize that when you do commercial litigation, it's all about time.
As a practitioner, if you are up and doing, you can make as much money from ADR as you make from litigation, even more. In any case, a serious lawyer should not be charging what we call appearance fee. You should be charging your fees upon being briefed. So whether the matter is then resolved by ADR or by litigation, you are going to be paid your fees anyway, because at the end of the day, you are going to be doing the same amount of work.
The chairman of the LMDC Governing Council, Justice Olateru Olagbegi, hopes that this roundtable will change the perception of the society, and especially lawyers, on the expediency of ADR.
Well, we are hoping that in the days and years ahead, that lawyers and the public would have become much more knowledgeable about these matters, and that they would embrace ADR practice more, and that will decongest the courts. Indeed, when we were here, there was news coming around that even some courts are being shut down in Britain, and it's a trend that is going to become perhaps more common as the years go by, because every person who has a matter to resolve really puts timeliness into the situation, and what is worth doing at all is not just worth doing well, but worth doing at the right time.
And that's the program for today. Please share your views with us on any of the issues we discussed on the program. If you missed this or any part of the program, you can find it in past episodes on our YouTube channel. I'm Shola Shayeli. Thank you for watching.